So proportionality is not about weakening enforcement, but it's rather about ensuring balance.
I think the concern would be a phenomenon which I call predatory infringement.
So we conclude it's better to move Huawei to the US rather than bringing the full factor test to Europe.
That would be my greatest wish for the SEP world.
You're listening to IoT and IP Explained with Claudia Tapia, where experts discuss the latest in technology and intellectual property.
Welcome to IoT and IP Explained. My name is Claudia Tapia and I will be your host today. In this episode, we explore the question that is drawing attention. Should we bring the full factor test from the US to Europe when assessing injunctions? Let me start with the legal background. In the EU, the enforcement of IP rights is governed by the Directive 2004/48/EC on the enforcement of IP rights. You might know it as IPRED. IPRED has been in place for more than 20 years. It sets the framework for civil enforcement across the EU. This includes injunctions, damages, and other remedies. At the heart of IPRED is the principle of proportionality. Proportionality means that enforcement measures must be fair and balanced, and they should be effective and discourage infringement without being excessive or causing unnecessary harm. So proportionality is not about weakening enforcement, but it's rather about ensuring balance. It requires courts to ask a concrete question. Is granting an injunction in this specific case justified, considering all interests involved? At the end of January 2026, the European Commission published a study on the application of IPRED. This study reviewed more than 600 court decisions of selected EU member states. And one of its most discussed findings is the following. Those selected courts analyzed granted permanent injunctions in 94% of patent cases, but proportionality was explicitly assessed in only 0.6 of those cases. The study suggests that this could indicate that injunctions are granted in a rather automatic way. It also raises concerns that this may affect innovation and licensing dynamics. In particular, in standard essential patents, also known as SEPs, it suggests that limited proportionality analysis may give patent owners stronger leverage. The study therefore proposes the Commission to issue guidelines identifying factors for courts to consider when assessing proportionality. What I found most interesting is that the study points to the US approach as a source of inspiration. In the United States, the Supreme Court clarified in eBay versus MercExchange that courts should not grant injunctions automatically, and instead they must assess 4 specific factors before doing so. Today, we will go through each of the 4 eBay factors one by one, understand what they mean in practice, look at the impact of the decision in the US, discuss whether it makes sense to draw inspiration from it in Europe, and reflect on whether proportionality is truly needed in SEP cases. I am very pleased to welcome today's guest, Professor Kristen Jakobsen Osenga. Kristen is Associate Dean for Academic Affairs, Julie and John Nowak Faculty Research Scholar, and Professor of Law at the University of Richmond School of Law. Kristen, welcome to the podcast. It is a pleasure to have you here.
Thanks, Claudia. I'm so happy to be here.
eBay is a case from 2006. And my understanding is that it did not involve SCPs. Is that correct?
That is correct. So just very briefly, MercExchange was a startup. And they were developing internet technology, specifically shopping technology, and they hoped to do something with that. Their business didn't launch, but they still had received patents on the technology they had developed. And so when their business failed, they attempted to license those patents to bigger shopping online retailers, such as eBay. eBay chose not to take a license and decided to infringe, and then we went into court to determine whether or not MercExchange's patents were infringed or not.
And before eBay, how were injunctions typically granted in the US patent cases?
Yeah, so before eBay, by and large, if the patent was found to be valid and infringed, an injunction would generally issue unless there was a very good reason not to. For example, public health. If we grant the injunction, then a city won't be able to take care of its wastewater treatment, something like that sort of public health. So it was relatively automatic. They did consider the public's interest, but it was studies showed anywhere between 95 and 99% of cases where infringement was found, an injunction would issue.
Right. And following the decision, my understanding is that now courts need to consider 4 factors before granting any injunction. If we start with the first one, irreparable injury, what does this mean in practice?
So courts are supposed to consider the 4 factors. I will say from studying this for quite a bit of time, they don't always walk through the factors one by one as we're hoping to today. Sometimes they just make an assessment based on who the patent owner is, and we can talk about that. But back to the factors. Irreparable injury. This is the idea that if an injunction isn't issued, the harm will not be able to be fixed. This is really looking at the harm to the patent owner and whether or not there's any way money damages can satisfy that harm.
What kind of evidence do courts look for to establish that?
So the problem is there's not a lot of cases where they're looking at the evidence. So I don't have a lot of great answers in this particular case. But if we think about it from other areas of United States law, irreparable harm might be things like loss of reputation. Can't get your reputation back with money. Maybe losing market share because you've lost the first mover advantage because the infringer has now become the popular choice for the consuming public. Things that normally cannot have a money tag put upon them is usually what we think about as irreparable harm.
So that means that in most of the cases, courts consider that monetary damages are sufficient?
In most cases, they assume they aren't, except for certain types of patent holders for whom the courts have sort of determined, no, money damages are probably good enough for you. So what you have just done actually is what the courts do, is it's very hard to navigate between the first 2 factors as being different in kind. So the first factor is irreparable injury, and the second factor is money damages won't make whole. And there's not a great line between those. So oftentimes they conflate. And if a court determines that money damages can make you whole, then you don't have an irreparable injury. If money damages can't make you whole, you might have an irreparable injury. So they don't really separate out the factors in the way that you would expect them to, even though they are discrete factors in the case.
Right. And you mentioned, I believe twice, the issue that they are not really always following those factors, but they are looking at who is the patent owner. And I imagine you're mentioning the business model. Can you share a bit about that?
Sure. There are 2 types of patent owners for whom those first 2 factors usually weigh against injunctive relief. And those are SEP owners of standard essential patents, and patent licensing firms. And the way the analysis in both of those cases goes is with SEP owners who oftentimes have obligated themselves to a FRAND commitment, meaning they have decided they will license on FRAND terms. The courts say, well, you've agreed to FRAND, so therefore money damages must make you whole. So no irreparable injury. And for patent licensing firms, the same sort of analysis, right? If you are in the business of licensing your patents, you've already accepted that money damages or money is what you want for use of your patent. So you aren't damaged if you get money, and no irreparable harm. Those two particular patent owners, courts look at who they are and their business model, as you suggest, and determine money is enough. And so therefore, we are not going to issue injunctive relief. And studies after eBay show that those two types of patent owners are disproportionately not receiving injunctive relief, whereas operating companies suing their competitors are still receiving injunctive relief nearly all of the time.
Oh, wow. So, but when I look at SEPs and I see the promise is basically to be prepared to grant irrevocable licenses on fair, reasonable, non-discriminatory terms and conditions, this is basically a promise to provide access in exchange of those rights, but it goes implicit also that it has to come in a timely manner, because otherwise, and for me, when I'm thinking about proportionality, I have to think about this balance of interest. So, and the harm that this could go to innovation if there's absolutely no incentive to engage in good faith licensing negotiations. If I look at my company, but also the innovators, like we rely on these investments in order to be able to invest in the next generation of these standards. So what I have observed is that has led to companies also look into the ITC. Could you share a bit more about that?
Sure. So the ITC in the United States offers a different type of relief. It's not a court, it's an administrative body. And so they don't have the ability to grant monetary relief. Instead, the relief that the ITC or International Trade Commission gives in the United States is the ability to get what's known as an exclusion order. And so that's essentially an injunction on importation. And so you can keep infringing products from being brought into the United States if the ITC finds that your patent is infringed by goods that are being imported. There's a couple of wrinkles there. It's only available, the plaintiff has to have a domestic industry that needs to be protected, because the ITC is at its heart in the United States a trade court. And so it's meant to protect the United States industry and innovation. And so it's not available to companies, even if you have a United States patent, if you don't have a United States industry, you don't have domestic industry, which can be shown by marketing, sales, research. You have to have something happening in the United States in order to avail yourself of the ITC. But at the end of the day, all you get is the ability to stop importing of goods, importation. And so that's valuable in some cases, but not always. Sometimes the infringing goods are being produced in the United States or are already here.
Exactly. And when I look at the ITC, they're also looking at the behavior. Like, for example, my understanding is that they look at the patent owner has made, the SEP owner has made a front offer, or that has been negotiated towards that offer. So in a way, it's also looking for a certain balance. And when we're looking at non-practicing entities, this also includes maybe small inventors that at the end they didn't manufacture, but they would like to recoup for, you know, the investment and these ideas that someone has decided to implement, so they must found them valuable. Or universities, are they also included in these kind of entities that, of course, decide damages is good enough?
Definitely with the small companies that don't manufacture and are simply licensing their patents, injunctive relief is hard to get. Universities, still hard. They oftentimes don't, although some courts have carved off kind of a soft space for universities with the understanding that they are somehow in kind different. At the end of the day, they are just receiving money for licensing their patents, so they should fail the eBay test. But those entities oftentimes can't avail themselves of the ITC because they don't have a domestic industry. There's a variety of different patent owners for whom the eBay test causes injunctive relief to be very hard to get. So universities, small inventors, patent licensing firms, whether they develop the patents themselves or they acquire them, and certainly SEP owners have all found themselves at the United States courts lacking the ability to retain certain injunctive relief. Sometimes it happens, but it's rare.
We talk about irreparable injury. We talk about monetary damages being enough. And I suggest we move now to the third factor, which would be balance of hardships. Could you tell us about this test?
Sure. This one doesn't often get talked about by the courts at all. They basically see this as a business fight most often, and so there's not really an imbalance between the parties. In the United States, when we think about balance of the hardships more generally, things we might be thinking about are, is one of the parties going to go out of business if an injunction is or is not granted? That's something that might play into balance of the hardships. But most often courts in the injunctive relief space don't, particularly permanent injunctive relief, don't generally consider balance of the hardships. Balance of the hardships comes up far more often in the United States, I believe, when we're talking about preliminary injunctions before a judgment is offered. And that's because we don't want a company to go out of business while we're still deciding the merits of the case. And so in those cases, we're much more concerned about balance of the hardships. But with respect to permanent injunctions, it's not often considered. Courts just kind of glide over it.
Oh, wow. That seems a bit extreme, like just going out of business, just the only criteria that they are looking at?
I do not know of a whole lot others. Like I said, it's not often discussed in the cases as to balance of the hardships, or the balance of the hardships is deemed to be even, right? The patentee has lost the ability to exercise their patent in the way they wish, and the defendant now is going to have to pay for having infringed this patent, and which seems fair to me, but the courts look at it and say, well, everybody's even Steven now.
I see. And maybe now to the fourth factor. In which scenarios does the public interest outweigh the right to exclude? And you mentioned one example. Can you think about other examples?
So courts that have been willing to grant injunctive relief to patent licensing firms or SEP owners have looked at the public interest and focused on what a patent is intended to do. And so they actually say, hey, a patent is supposed to give the patent owner a right to exclude. In order for the patent system to be strong, effective, and reliable, we need to actually allow injunctive relief to issue. That's the public's interest. I love those cases. On the other hand, we've seen cases that have gone the other way and are very much thinking about the public's interest not in a strong patent system, but instead on consumers' preferences. And so some courts will go so far as to say, hey, we can't possibly grant injunctive relief in this case because the public really needs their next gizmo. And so in order to enjoin the company that's making the gizmo that people are buying off the shelves, that would be against the public's interest. Now, those are two extremes. There's not many cases that focus on the patent system being strong as being the public's interest. There's also not a ton of cases where it's the courts are like, it's the public's interest to have gizmos. And so, again, the third and fourth factor oftentimes don't really come into play or don't carry a lot of weight in the assessment. It really boils down to those first two factors. And then if we go back to those, it really boils down to, are you a patent licensing firm? Are you an SEP owner?
Okay. Seems all clear now about the four-factor test. is since 2006, what has changed in the US patent law after eBay?
So after eBay, injunctions are not nearly automatic. As I mentioned, they're still pretty automatic if we have an operating company suing an operating company competitors. Courts will sometimes give voice to the eBay factors, but it's really, we're going to go ahead and grant your injunction. What we've seen is more often than not, SEP owners and patent licensing firms will not receive injunctive relief. It's kind of a flip. Instead of, 90% of the time there will be an injunction, it's more like 80% of the time those two types of patent owners will not receive injunctive relief. The numbers flex depending on who's doing the study, but it's down in the 75-80% don't get injunctive relief if you're an SEP owner or a patent licensing firm. But the most interesting study that I've seen recently is one done by Christina Acri, who's an economist. And what she has found is even operating companies are not always seeking injunctive relief because they don't want to get into the hassle that eBay has caused. And so if you take those into account, the number of companies that probably could receive injunctive relief but aren't even asking for it, the decrease of injunctive relief being granted in the United States drops dramatically. And so sometimes you'll see those numbers be very low across the board. Just injunctions are only issuing in very few cases in the United States, and that's taking into account companies that don't even seek injunctive relief. And so I think that's the biggest change that we have seen is why not ask for the only thing a patent gives you, which is the right to exclude.
And sometimes you don't want to license.
Right.
You want to build your business from that. It's part of the deal, right? You disclose, but in exchange, you have exclusionary rights.
Yeah.
So looking at Europe, what benefits and risks could arise if Europe will adopt a similar test?
I think the concern would be a phenomenon which I call predatory infringement. Other academics and commentators sometimes call it efficient infringement, but that makes it sound like a good thing. And that's the idea of if an injunction is thought to not be likely, for example, if you're a patent licensing firm or an SEP owner, it's unlikely you're going to get an injunction. Your infringer has every motivation to infringe now, pay later. And that's not a great scheme. And it's costly. It requires court to get a resolution because the infringer has declined to license. They're just going to wait, take it to litigation, and then pay the rate that the court determines, which Jonathan Barnett, a fellow professor, has determined is oftentimes much lower than negotiated rates. So that's a concern, is that if in Europe they adopt the eBay framework, will they also then adopt the idea that certain plaintiffs are unlikely to get injunctive relief? And if so, then does infringement follow? I think rather than having Europe adopt eBay, I'd really love to see the United States adopt the Huawei framework, quite honestly. So I think that's one of the benefits of Europe, is that they have a system by which they can assess willing licensees, which then goes towards the proportionality discussion. But in the United States, we don't have this framework, and courts have been reluctant to determine who's a willing licensee, focusing on the identity of the patent owner and whether or not money damages are good enough.
Yeah, the way I see it, when we focus on SEPs, proportionality is already part of the European framework. As you said, in SEP cases, an injunction is not granted automatically after infringement. Instead, the court looks at the conduct of both parties, and this framework was established by the Court of Justice of the EU in Huawei versus CT in 2015. So this means that the patent owner must first alert the implementer of the infringement, and after the implementer has expressed its willingness to engage and sign an upfront deal, to make a concrete upfront offer. And the implementer has to respond seriously and without delay. And should the implementer disagree with the offer, it must make a upfront counter offer. So if the counter offer is rejected by the patent owner, the implementer must render accounts and provide security. So it's a whole kind of steps, but it's not a rigid system. It's rather looking at the conduct of the parties. So in practice, this means that courts are already applying a form of proportionality. They assess whether granting an injunction will be fair in light of the behavior of the parties and the licensing context. So even without using the word proportionality, the Huawei versus CT framework ensures that SEP enforcement in Europe is not automatic, but conditional and balanced. So I hear that for you, you're also a big fan of the system. Is proportionality particularly relevant in SEP disputes, or is this FRAND framework sufficient? Do we need more than what we have in Europe?
I don't think you need more. I think the balance created by the Huawei versus ZTE framework is ideal. It puts both parties, both the innovator and the implementer, on a level playing field. They both have to behave well. And at the end of the day, the outcome should be a FRAND rate negotiated between the parties, which is the point. And if the licensee is unwilling to engage in this behavior or continues to not be willing to pay a FRAND rate, injunctive relief is possible. And so that takes care of the concern about predatory infringement, the idea, well, I'm just going to infringe, and at the end of the day, the worst off I'll be is having to pay the license I should have paid to start with, and probably at a lesser rate, which is the motivation in the United States, where we don't look at the party's behavior. So I think that proportionality is probably fairly covered by already the Huawei framework.
So we conclude it's better to move Huawei to the US rather than bringing the full factor test to Europe.
That would be my greatest wish for the SEP world.
Okay, hopefully someone is listening who has something to say. Before we close, many of our listeners may want to explore this topic further and read your work in more detail. Do you have any recommendations? I would definitely share a link that you have with your papers, but is there anything concrete that you would like to point out right now?
Yeah, I have a paper from 2022 that I think is probably the most helpful on this topic, and it's called Efficient Infringement and Other Lies. And it specifically talks about how eBay changed the analysis, how it directly impacts SEP owners, and why, air quotes included, efficient infringement is not efficient after all. So I think that paper would be spot on, but the link that I shared has all of my work, and your readers may enjoy it.
Excellent. And before we wrap up, I'd like to move away from the legal aspects for a moment and ask you something more personal, which is, could you share with the audience a lesson learned?
Don't be afraid to go beyond your comfort zone, whether in your work life or in your personal life. I started as a patent person. I didn't understand SEPs at all, but I got interested and I started reaching. And now I also consider myself to be an antitrust scholar, even though that never would have been part of my comfort zone. But personally, I'm a long distance runner and I'm always seeking to run further than I have before. And it's not comfortable, but the reward of reaching some place that you haven't been before, whether it's in your work life or in your personal life, is really quite amazing.
Indeed, it is. Thank you so much. As we come to the end of today's episode, let me briefly reflect on what we have discussed. We have seen that proportionality is not missing in Europe, and in particular in the context of standard essential patents, proportionality is embedded in the framework developed by Huawei versus CTE decision. We also see that courts do not grant injunctions automatically. They look at the behavior of the parties. We have also discussed that the European and US systems are kind of different, and while the US relies on a structured 4 factors test from eBay, and Europe already applies a balanced approach within its own legal framework. And perhaps the key takeaway in this is that importing the US test in Europe may not solve a real problem. It could instead add complexity and uncertainty to a system that is already working in a nuanced way. Kristen, thank you very much for sharing your insights today. It was a real pleasure having you on the podcast.
Thanks so much, Claudia. This was so much fun.
And to our listeners, thank you for joining us on IoT and IP Explained. We hope you found this discussion useful and clear, and if so, we will appreciate a good review. You can find me in LinkedIn under Dr.-Claudia-Tapia. Please feel free to reach out. As I love to say, connected, we go further. Thank you.